Welcome to this UKLFI Charitable Trust webinar on judicial reform in Israel, assessment and prospects. The debate over judicial reform in Israel continues, and it's my privilege to bring you two legal academic heavyweights representing both sides of the argument, each affiliated with a major think tank described as shaping the conversation, the Israel Democracy Institute and the Kohelet Policy Forum. Professor Yuval Shany was Vice President of Research at the Israel Democracy Institute until last year. He currently serves as a Senior Research Fellow there. He holds the Hirsch-Lauterpacht Chair in International Law and is the former Dean of the Faculty of Law at the Hebrew University. He was a member of the UN Human Rights Committee, serving also as its chair, and his research focuses on international law. Professor Avi Bell serves as a senior fellow at the Kohelet Policy Forum. He is a professor at the University of San Diego School of Law and at Bar-Ilan University's Faculty of Law, and assists various non-profit organizations with training, legal advice, and strategic direction. He's on the board of directors of NGO Monitor, and he has consulted with and given testimony to officials, committees, and parliaments and governments and international organizations on 6 continents. It is great to have you both back with us for a discussion. With some reports out of Israel today that negotiations mediated by President Herzog may be bearing fruit, it's as important as ever, ladies and gentlemen, that we set aside hysteria and empty platitudes that have engulfed much of this debate and drill down to the objectives of the proposals and the substance of the reforms. And after opening remarks from our speakers, we will be taking your questions, ladies and gentlemen, from the Q&A facility on Zoom. So Yuval, could you kindly start us off with the key issues raised by opponents to the reforms and any thoughts you may have on a potential compromise?
Okay, thank you, Natasha, and thank you all for joining us. Let me perhaps start with, I don't know how much the audience is familiar with all the twists and turns in Israeli constitutional law. Let me dedicate a couple of minutes in the beginning of my presentation to basically bring us up to speed as to why, in my view, we got where we got, what is on the table in terms of what is being proposed, why I believe it is a very problematic set of proposals, and maybe what could be a possible way forward. And I'll try to squeeze in these comments that we could use a whole seminar, academic seminar, to discuss within 15 minutes. So as many of you know, and those of you who have been on meetings around the Israeli legal system know that Israel is a country that has a very unclear or very unique constitutional history, in the sense that it was established in 1948 without a constitution on the UK model, but it did aspire to have a constitution. And in fact, the Declaration of Independence does mention the writing of a constitution. There were even elections for a constitutional assembly. But the project of writing a constitution hit a roadblock very early on. So instead of having one comprehensive constitution, as most countries in the world have, Israel has selected to follow a more gradual path, by which the Knesset would pass from time to time basic laws, and it has done so on 13 different occasions over the years. And at least the original intent of the drafters was that these basic laws would form chapters in a future constitution, and eventually Israel would have a whole constitution. However, and here is, I think, it's a big however, the body that is passing these basic laws is the Knesset. It's no longer the Constitutional Assembly. And they are passed in the same procedure in which ordinary laws are passed in Israel, sometimes even without a majority of Knesset members, namely no more than 61 members of Knesset voting for this. So this is a very peculiar way of forming a constitution, and I believe that this is very much at the root of a lot of the back and forth that we are seeing in Israel. Now, like many other democracies, I should say, that did not have a constitution or a strong constitution, Israel became more, and the Israeli legal system became more and more interested over the years in developing legal mechanisms that would curb executive power. And this is, I think we see it in many jurisdictions around the world, that with the rise of the administrative state, courts have started exercising more stringent powers of judicial review over governmental activity, and also became more and more interested in developing a human rights code. So we have seen in this country, for instance, the Human Rights Act in the late 1990s. We have seen in the 60s in the United States, the Civil Rights Act. We have seen in Canada in 1982, the Canadian Charter of Fundamental Rights and Freedoms. And Israel eventually also developed a very short Bill of Rights in 1992 under a basic law, which is called Basic Law, Human Dignity and Liberty. When the court actually was seized with this basic law in 1995, it did proclaim this basic law to be constitutional in nature, both in the sense that it derived from the original process that was launched by the Declaration of Independence, and also, perhaps more controversially, by noting that it read these basic laws as giving the court power to strike down Knesset legislation that is incompatible with the language of the basic law. We can discuss in the Q&A whether the court was right or wrong. In doing so, I believe it was right. Maybe Avi would dispute that. But this is where we're at now, 30 years later, almost 30 years later. We have a very short constitution that protects some human rights, some democratic features. The court is applying this constitution in order to strike down legislation while also exercising judicial review over governmental activity in a variety of contexts. And this exercise of power has been controversial to some extent for many years. So I think this is what brought us to this moment in time. What I would also say that perhaps exacerbating this tension is that one path that governments in Israel found to circumvent what they consider to be a legal or a judicial straitjacket, that the court is reviewing Knesset legislation, and of course governments in Israel don't like the idea that the laws that are passing through Knesset are being struck down by the judiciary. They developed what we call a Kunstpatent, which is trying basically a trick, and that is to pass ordinary legislation while disguising it as a basic law. So even very technical issues such as changes to budgetary statutes, which is typically not the stuff you would find in a constitution, they were passed as amendments to basic laws in order to shield them from judicial review. And the court pushed back on that and actually indicated that it will not agree to validate legislation which masquerades as basic law, but is really an abuse of the form of what is a basic law. So we have seen somewhat of an exacerbation of the tension between the Knesset and the judiciary over the question of what are the boundaries of basic laws, because again, basic laws are passed by like ordinary legislation, and there is no real document that limits what could count as a basic law. Now, it is against this background that this current government has pushed for a comprehensive so-called reform, which seeks to significantly roll back a lot of the changes that have happened in Israel, some changes since the 1990s, some since the 1970s and 80s, some even since the 1950s. And to radically realign the balance of power between the three branches of government. And it is done so through a package of bills that would take away a lot of power from the Supreme Court and place it with the Knesset. But in the Israeli specific context, it means that the coalition that controls both the government and the Knesset would be free from meaningful checks by the judiciary on a number of issues. Now, we can go into the minute details maybe later. I will just note for the present that there are 4 specific areas where bills have been either put forward or there have been an intent to submit such bills that was declared by either the Minister of Justice or by other senior coalition officials. One bill is a bill that reforms or changes the way in which judges are selected in Israel. Up until, well, from 1953 onwards, judges in Israel have been selected by a selection committee on which politicians sit, but they are in the minority. So the majority of members on the selection committee are members of the legal profession, either judges or lawyers, and the proposal is to roll this back, give politicians the majority, and not only politicians in the abstract, but rather give the coalition a decisive control over the selection of judges in Israel. So this is one bill, and this is the bill that is closest to passage. It is already ready for second and third reading in the Knesset. So it's technically, it could be passed within a matter of days. The other ideas or the other bills that have been put forward deal with other specific issues. One of them renders judicial review by the court much more difficult, in the sense that the court would not be able to review basic laws, regardless of the way they are passed or regardless of what is found within their contents. Even when reviewing ordinary legislation, the court would have to adopt a supermajority in order to strike down legislation. According to one version of the proposal, all 15 justices would have to support striking down a law for that law to actually be struck down. Even when the court strikes down the legislation under these almost impossible conditions, the Knesset could restore, by a simple vote of 61 members of Knesset, could restore that legislation. So effectively, this second bill would do away with the judicial review of legislation in everything but name. Other bills deal with taking away from the court the power to review the reasonableness of administrative acts, which is a specific issue relating to administrative law. And the fourth and final bill deals with the issue of legal advisors, which in Israel is a very important, play a very important role in facilitating and internalizing court judgments within the state executive apparatus. Now, the combined effect of these laws, and I think this is why they have raised so much consternation, apprehension, resistance in Israel, that they basically do away with separation of powers as we knew them, and as we know it, and as we have learned to know this idea in Israel, in the sense that they would concentrate all of the political power in one locus, and that is the coalition. So the coalition controls the Knesset. It has a majority in Knesset. Otherwise, it is not the coalition. It is not a coalition. It forms the government. So the coalition also controls the government. And if these proposals would go forward, the coalition would have a decisive influence on the composition of the judiciary, but also effectively be in a position to override the judiciary whenever the judiciary is reaching decisions that are unfavorable to the coalition, and that effectively renders judicial review devoid of effectiveness. So even if one has legitimate grievances about the court as being too activist and overreaching in its activities, which I would incidentally say, I mean, there are fair criticisms of the court. If we get to the Q&A, to discuss this in the Q&A, I would also elaborate further on this, but it's also important to say that there are also criticisms directed at the court from exactly the opposite direction, which say that the court has been actually too timid over the years and has actually allowed governments to implement very dubious policies on issues of great importance. But even if the criticisms about the court from either side or both sides are correct, the cure here is far worse than the problem that we have been dealing with, and that is that there are some questions of uncertain lines between the different branches of government. Now, moving to close, because I see that my time is running out very quickly, I will say that there are perhaps three issues that I will just very telegraphically note. First, I think it's important to realize that part of what we are seeing, the unrest in Israel, the demonstrations, the very significant pushback by civil society, by different groups, has to do partly with the democratic implications of interfering with judicial independence, checks and balances, and the like, but partly also with the process by which these reforms are being pushed. They're being pushed very aggressively, very quickly, in ways that do not actually sit well with an idea about writing new rules of the game in ways which would reflect a broad societal consensus. And if those of you who are following the news in the last 2 days have seen that the Moody report on the creditworthiness of Israel that has been somewhat moderated or downgraded, depending on your perspective, actually identify this issue of the process as being a serious area of concerns. So this is one thing that is on the table. The second thing is, why is it happening now? And I think this is also a lot of people are concerned about why is it happening now. And part of the reason is that you do have now in power in Israel a coalition of people who have long advocated for these reforms because they were long concerned about the powers of the Supreme Court, and maybe the Kohelet Forum belong to that category. But there are also politicians who are pushing for these reforms for more nefarious reasons, such as their own criminal trials, which are pending, and they see this as a way to either get back at the judiciary or make their legal situation more favorable, and some specific agendas which some politicians in the coalition try to pursue, such as granting the ultra-Orthodox an exemption from military service, or taking up more land in the West Bank as part of Israeli settlements, and they see the court as a strategic obstacle to this. So some of the resistance has to do with the agendas that are lurking behind these reform proposals. And finally, going forward, I will just say that, as you said, Natasha, there are negotiations currently. So we have seen a strong pushback by large segments of the Israeli society. I think the reform as planned, I think there is broad agreement among observers that it is highly unlikely that the whole package of reforms would actually pass. Even the coalition has diluted some of its reform proposals that are on the table. There is a process which the president hosts. That process may lead to some political compromise. I would know that our Israel Democracy Institute has been consulted on what is called the President's People's Directive, or the President's Compromise solution. And although there are some aspects there which we find, I find and some of my colleagues find as very problematic, we did think that this could be a reasonable way forward. So far, the government has not endorsed that specific proposal, but maybe, of course, one could continue these discussions, and maybe we will come to a solution that is acceptable to both parties. At this point in time, we're not there yet. So maybe I'll stop here, and after listening to Avi and the questions, we can come back to some issues. Thank you very much for your attention.
Well, thank you, Yuval. We've already had quite a number of questions coming in, but before we get to them, Avi, could I turn to you for an overview of the substance of the reforms and perhaps what has prompted the proposals? You're on mute, I'm afraid. Timeless words.
Thank you very, very much for having me, and thank you also, Yuval, for your remarks. I'm actually going to pattern my own remarks in part on what Yuval did. I actually want to start with the history. I think that it's important to understand where we were to understand where we are, and there's something interesting about the way that Yuval presented things that I want to highlight. There's places where he described things in passive that I would describe in active voice. Places where he put things as understood and traditionally accepted narratives of history that I think are highly controverted. And so let me just give you a quick overview from my point of view, and I'll highlight the differences as we go along. So. The way I see Israel's legal development, there have been more or less two periods in Israel's legal development. There is Israel's, it was more or less from the first Knesset, that is after the Constitutional Assembly disassembled and reassembled as a Knesset, and until more or less the ascension of Aaron Barak to the Supreme Court and his far-reaching, I would say, revolution, and the period since Barak, Barak's revolutionary period and the ongoing revolution that his successors have carried on. And these are two very different Israels. The Israel before Barak was modeled on the UK in its constitutional structure. It was a traditional Westminster democracy with parliamentary supremacy. Now, I have to say, this Israel before Barak had an incredibly activist judiciary. Right? So pre-Barak, the Israeli Supreme Court worked out a way to shoehorn human rights review into administrative law. There's a very famous case called Kol Ha'am, in which the court interpreted general administrative principles as requiring that administrative action be in accordance with certain human rights norms, and that if it failed to do so is unlawful. And even in the late 1960s, in 1969, the Supreme Court, in a case called Bergman, came up with an interesting amendment to the general rule that parliaments could not bind future parliaments. And in Bergman, they came up with the idea that while parliaments are unable to bind the decisions of future parliaments, they can determine rules of procedure that will be binding. And so if there is a law, a basic law that has an entrenchment provision, a substantive entrenchment, a numerical entrenchment provision that says that it can only be amended by a certain number of votes, then the Supreme Court can use that entrenchment provision to strike down a piece of legislation that failed to win that number of votes. Now, it's not striking it down permanently. It's basically sending it back to the Knesset for another vote that actually follows the procedure. And that's what happened in Bergman. In Bergman, the law that the court struck down was one that provided funding for political parties. The court said in one of the votes, the proposed legislation didn't get all 61 of the required votes. It went back to the Knesset, and more or less we have the same party funding law that was struck down then. We still have it today. Right? It was a purely procedural view, but then this nevertheless is a big chink. I imagine that to Dicey, this would have been unthinkable. Right now, that's the classic version of Israeli constitutional law, Israeli public law, the Israeli legal system. And then Barak came into office. And when Barak ascended to the Supreme Court, he began a process, and it was deliberate, of changing everything. I mean everything. Right? Criminal law, civil law, public law, administrative law, and most importantly, changing the institutional powers of the courts, which he aggrandized in every imaginable way. Right? Now, this is not an observation of mine. This is an observation that was made at the time, right? So already in the 1980s, Manny Maudner in Tel Aviv, who is a figure who strongly identifies with Barak's political agenda. That is, he not only does he view the power aggrandizing as advancing liberalism. I don't, but he does, and he thinks that liberalism is essential to the government. And certainly politically, he aligns with the alignment of most of the court on the left. But nonetheless, he pointed out that in the 1980s, before Barak even carried out what he called his constitutional revolution, he pointed out that Barak had changed everything. And he pointed out also the political dimension of it. The political dimension of it was that Barak and his court were doing this just after elections where, for the first time, the Labour Party had lost control of the government. And so there was, for the first time, a Likud-led government. And this was an opportunity to transfer power from the elected branches, which were now in the hands of the great unwashed, to a preferred elite. And it was Barak's elite. Barak called this elite the enlightened public. Now, the changes that he made were far-reaching. They included a substantive judicial review of legislation, which was not possible before then. This theory that Yuval presented, that basic laws are constitutional, that they have constitutional substance before some future proceeding in which the proposals are wrapped into a constitution. That's Barak's theory. That's not the generally accepted theory, right? The generally accepted theory before Barak declared that there had been a constitutional revolution was Dicey's theory, right? Israel has no constitution. Parliament is supreme. Only Parliament can bind itself, and it can't bind itself, except for this one exception that the court created in Bergman, where Parliament could bind itself in matters of procedure. And it was unthinkable to have, therefore, a court striking down legislation in any way that all it could do was it could tell the Knesset, go and enact this by the proper procedure. He did that. He gave so-called legal advisors, he turned them into legal commissars, where their legal opinions and their political opinions are binding law. Binding law to such an extent, by the way, that they not only can disregard the decisions of elected officials, but they can refuse to allow the elected officials representation in court to represent their own opinions. Right. They eliminated all procedural barriers to getting into court to allow the court to get to every political issue possible. They created this thing. This is one of Barak's earliest innovations. They created this thing called reasonableness review, in which under the term reasonableness, in a way not used anywhere else in the world, they essentially engaged in judging the political wisdom of the decisions of all actors, those elected and those not elected. There was one thing that Barak did that was not formally on the charts, but has turned out to be quite important to the judicial reform debate, which is he seized control of the appointments process. This is something that was not as a result of any change in law, nor any specific decision of the court in a case. It's more a matter of he recognized the authority that he could grab there, and he organized the judges as a voting bloc. He worked the system and essentially exercised veto power informally. Eventually, it became formal over the appointments of all judges who didn't share what he called his agenda. He didn't agree that he had an agenda. He described those who didn't share his agenda as having an agenda of their own. Now, all of the reform, all of the judicial reform that's been proposed is entirely about the Barak Revolution. Right? There are only two blocks of reforms. One of them is to reverse or curb, for the most part to curb, not to reverse, central doctrines that were created by the Barak court and thereafter. The other one is to modify the appointment system, which predated Barak, to prevent a seizure of the Supreme Court the way that Barak seized the Supreme Court during the 70s and 80s. Now, that's all there is to the judicial reforms. It's rather comic to hear them described as modifying the separation of powers as they've been traditionally understood in Israel, when it's fairly clear. This is one of the things that's interesting. You know, Yuval acknowledges that there was these massive changes. He doesn't say the name Aaron Barak, but these massive changes that led us to what we have today. But doesn't acknowledge that there used to be parliamentary supremacy in Israel. Right? That was it was a very clear, the very clear state of things before Barak, or certainly before Bergman, but even after Bergman, there was still we were still in a parliamentary a system of parliamentary supremacy, and it creates this anomaly where Israel is the only country in the world where a Supreme Court exercises a power of judicial review over legislation that is unbounded. It's unbounded because there's no written constitution, and the rules that the court has made keep changing. So at one point they justified it as basic laws are a constitution, and then they said, wait, basic laws aren't really a constitution. They're only a constitution if they're worthwhile. And how do we know if they're worthwhile? Well, we know if they're worthwhile. And so we can strike down basic laws that are not worthwhile or they're badly motivated. And we can also strike down legislation, whether there's a basic law that deals with it or not, if the legislation was badly discussed, if we're not convinced that there was a worthy parliamentary procedure. And so on and so forth. We have this situation which now the allies of the Supreme Court and believers in judicial supremacy, such as the many fellows at the Israel Democracy Institute, are opining that the Supreme Court, if laws are enacted, returning its authority to something closer to what it used to be before Barak's revolution, the Supreme Court should simply disregard those laws and pronounce them void and keep on exercising all the powers it's granted itself, which should be shocking. Now, there's a reason why reform is absolutely necessary, in my opinion. It's not simply that I find the intellectual justification for Barak's revolution somewhat lacking. Now, there are more important matters. And one of these is that the court, by doing this, has politicized itself and all of law enforcement. By pushing itself into every public policy issue, the court has made itself an arbiter of public policy issues on grounds where the law itself cannot possibly supply answers. It has made itself an arbiter of politics. It has made itself a player in politics. And this has led to a dramatic erosion of public trust in all legal officials, including the Supreme Court. It's faster than it's occurred elsewhere in the world, and extremely dramatic to the point where there are only single digits of the public that have faith in the Attorney General, for example. Right. It undermines democracy. And I'm not talking solely about the principle of the matter, although I am also talking about the principle of the matter, that democracy is the rule of the people. But it's also, democracy involves necessarily compromise, where there are imperfect solutions that are adopted as a result of bargaining between the different power centers in society. And the Supreme Court just walks in and imposes its own opinion, again, without any clear law. And so one of the debates that's been roiling Israel for many, many years has been a draft of ultra-Orthodox Jewish citizens. And there were several compromises that were adopted by the Knesset. You can like them, dislike them. I'm not a particular fan of any of them, to tell you the truth. But they were compromises, right? And they were compromises that were adopted for a reason, right? For political reasons, that is, bargains between the different political centers. And the Supreme Court struck down one, and struck down another, and struck down another one. And it's fairly clear that as long as the Supreme Court exercises unlimited power, it's going to keep striking these down, because that doesn't interest it. It doesn't work by democracy, right? That's not the governing principle of the way that the Supreme Court makes decisions. I think that the Barak Revolution destroyed the rule of law. The rule of law is supposed to be not the exercise of the will of judges and legal officials. It's supposed to be the subservience of everyone to common rules. And you take, for example, the court's threat to, or the allies of the court's threat to disregard any laws that limit the court's power. And you're looking at something that is simply unbridled, unlimited will of the judges. And there's also, obviously, there's always been a political dimension to this. And Mautno talked about this in the 80s, where it's very clear that the court was leaning left rather than right. That's still the same case today, but I think that that's the least important of the problems. All right, now, I have only a few seconds, so let me just get to the public debate about this, and what we were going to go in the future. I hope we'll get in the Q&A, but I found the public debate about the judicial reforms alarming and destructive. There's a degree to which is just surreal. The argument that somehow or another the only true democracy is unlimited judicial supremacy is something I just can't believe that anyone would suggest seriously. The idea that the separation of powers requires an unlimited judicial supremacy, or that somehow or another, if the Supreme Court is limited to the powers that it exercised in Israel until before the 1990s, then Israel will no longer be a liberal democracy. It will no longer protect rights. These are all contrary to history, and they make, I think, no logical sense. And there's a degree to which there's this endless historical revisionism going on. There's everything. All the arguments that predated the Barak Revolution, the arguments that were occurring during the Barak Revolution, where Yuval will remember this as well as me, because he was a student during the time that Barak was ascending and implementing his revolution. His steps were extremely controversial. He couldn't even convince the majority of his colleagues in the Hebrew University. He didn't have to convince them. He convinced the majority of the colleagues in the Supreme Court, and the Supreme Court doesn't have to reason. It simply has to declare. You have this surreal debate, but what's much worse than that is the degree to which the debate has been both destructive and McCarthyist. That is, there have been these threats that if legislation goes through the parliamentary process, people will refuse to serve in the army. They're going out and engaging in international campaigns to describe Israel as illiberal, undemocratic, urging people to boycott Israel, to withdraw their funds, to divest. I think that this is just unthinkable and just mindlessly destructive. And it's accompanied by a degree of McCarthyism at home, where people who voice contrary opinions are not just shunned, right? Not just blacklisted. I receive almost daily death threats. Obviously, Yuval is not one of the people who is sending me death threats, but there's an environment in which there's this hysteria that's created that if we go back to what existed before the Barak Revolution, we will lose democracy in Israel. There are people who take it into their minds that there's one way to defend Israel, which is to engage in violence against these enemies of the Barak Revolution, enemies of judicial supremacy. And unfortunately, they've done it. Right. There's an alarming degree to which the public debate is just spun completely out of control.
Avi, thank you. Both of you have covered so much and it's prompted so many questions. I'm going to ask, to the extent possible, the shortest answers you can give to all of them, the better, so that we can cover as much ground. We've had some questions touching on the debate and the issues that you finished off by referencing just then. We've had some questions on the role of the respective institutions. So I mentioned the Israel Democracy Institute and Kohelet. And so I'm going to start with one to each of you before we would perhaps return to the substance. Avi, one questioner would like to know your role at Kohelet regarding advice given on legal reforms, especially on the appointment of judges to Rothman and Levin. And he says there have been articles in papers claiming that Kohelet now feels the government is going too far with the legal reforms. Please, could you comment?
I can say very briefly, I haven't spoken to either Yariv Levin or to Simcha Rotman. Simcha Rotman, by the way, is a former student of mine. So I've spoken to him many times, but I haven't spoken to them about judicial appointments. I think that in general, the proposals that were made by both of them were compromise proposals, and they were designed to be further compromised on. And let me explain by what I mean by that. Neither of them proposed wiping out root and branch the Barak Revolution. They all proposed various ways of limiting it, modifying it, curbing it. And as we've gone through the process, we've seen different proposals raised by each, moving from the original ones about other ways to limit, curb. And then, of course, they're all related to a central question, which there's no a priori answer, which is what's the best way to appoint judges when we have this historical experience of this seizure of power by the Supreme Court, contrary to the law. And I'm not sure that there is a one good answer to this. The system that Israel had before 1953 was appointment by the government and approval by the Knesset. That brought us some terrific judges, including the Justice Agonat, who issued the Kol Ha'am decision. I think that that would not be a bad way of doing it. Neither Levin nor Rothman suggested that. They're all trying to be more accommodative of those who want some form of judicial supremacy to continue. Although I have to say I'm a little bit skeptical of the ability to reach a viable compromise between those who want X and those who want everything but X, or they want not X. Right? There's not a lot of room there for compromise. But I very, very seriously hope that there will be. And I think it's a mistake to pin down, initial offers, continuing offers. Let's focus on the aim of where we're trying to go rather than the bargaining positions of the parties.
Okay, well, we'll certainly come back to the prospects and potential compromise. But Yuval, in a similar vein to the question to Avi, focusing on the contribution of civil society, I have a question here. I'm summarizing regarding the Israel Democracy Institute's involvement in proposals made by Gantz as chairman of Hamachne Hamamlachti in August last year, so under the previous government, to limit the ability of the Knesset to call for early elections or bring down a government with a no confidence vote. It continues. I've noticed in recent months that the talking points of opponents of the judicial reform proposals seem to come primarily from Israel Democracy Institute. Can you comment on the connections between the Israel Democracy Institute and the opposition parties, in particular on the matter of checks and balances and opposition to judicial reform? So to summarize, yes, go ahead.
Yeah, no, sure. I hope we'll have a chance also to return to the substance, because Absolutely. A lot of what Avi said, I strongly disagree with. So the fact that I'm not reacting doesn't mean that I endorse the narrative or some of the framings that Avi proposed. On the Israel Democracy Institute is an independent think tank which puts forward its idea, and it is happy to engage with discussions with any segment of the Israeli population and the political system that is willing to discuss it with it. So we are not partisan. Yes, we have been consulted by politicians from the left, but we've also been consulted with politicians from the right and from the center. Sometimes politicians take ideas that we put forward, such as what you alluded to about the question whether the Knesset should call for early elections too soon. This is something that actually was quite controversial within the Israel Democracy Institute itself, but there have been ideas of that nature. The Israel Democracy Institute also brought with the previous government, when there was a governmental committee to review some of the issues that are now being discussed. We appeared before that committee and we put forward our proposals. I believe that people from Kohelet also had the possibility to bring their own ideas. So I wouldn't say that the Israel Democracy Institute is affiliated with the opposition in any structural way. We work with whoever is interested in our expert research-based positions on these issues.
Perhaps drawing on both of those questions and and answers for both for a moment. I mean, both Kohelet and Israel Democracy Institute have been mentioned in the media as think tanks that have been involved in the issue of judicial reform, on opposite sides, of course. However, the involvement of IDI, it does seem to be generally treated as more positive or an expert contribution, and there have been many reports in the media that seem to insinuate something sinister about Kohelet's expert contribution. Is there anything that can explain the differing approaches? Perhaps Yuval and then Avi briefly, and then let's return to the substance.
I'm not sure that I'm in the best position to make observations about Kohelet. Maybe Avi could, Avi has described that Kohelet is under a lot of pressure. Of course, I wouldn't condone any threats of violence. That should be cleared. As I said, the Israel Democracy Institute is research-based analysis. I mean, it is not affiliated with any specific political agenda, and it is trying to keep what we regard to as necessary distance from the actual political wheeling and dealing. So we are not in the business of the horse trading that politicians are actually engaged in the actual formulation of solutions. When such solutions are presented before us, like the example I gave with the president's platform, we do express our opinion, but we are not part of the political horse trading. But I'm not comfortable in commenting as to why is Kohelet receiving more bad press than the IDI at this point in time. Maybe the agendas, I would say that the agendas of the reform generally is not a very popular agenda within Israel, and you do see very significant polling numbers of Israelis that oppose this agenda, about in a 2-to-1 ratio, and that may also reflect on on the way in which different entities which are supporting or opposing the platform are being perceived by the public.
Avi, would you come back on that briefly?
Yeah, I think let's separate between two things. So there's the question of Yuval says he doesn't know how Kohelet works. He has more of an idea of how IDI works, and I could say the same thing in reverse. I think that institutions like this, groups of experts that engage in public policy discussions are vital. Both Yuval and I have academic positions. That isn't really the place to pursue debates about public policy. I think that it's good to keep academia somewhat distanced from excessively political issues, and so I think that it's a good thing to have places where like-minded experts can gather and give and conduct research, which is primarily what Kohelet does, as well as the IDI, and give opinions. In that sense, that we're not really very different, and I think that we both play an important role, notwithstanding the fact that I tend to disagree with most of what I read coming out of the IDI, but I appreciate very much the research that goes behind it and hearing the opinions. That I think has very little to do with the treatment. I mean, there's a campaign that's been going on several years. I can collect. I have collected, but I can send you the clippings describing the Kohelet policy forum in various conspiratorial terms. That some dark, evil conspiracy. There's even headlines describing its tentacles. Right, illustrations in Haaretz newspaper showing the people on a board connected by red string. You can't get more conspiracy-minded than this, and it's no wonder that when people are hearing this about an issue that they get hot about, that there's some dark, evil conspiracy that's trying to control them, that they get quite exercised. And it's not just the hoi polloi. I'm sorry to say, I don't want to name him, but the colleagues, a colleague of both of ours at a different university, at Tel Aviv University, wrote to me to say that I and all the people in Kohelet really have to repent now. Repent. This is very, very strong language. I think that it is part of a more general phenomenon, unfortunately, that goes on in Israel, where you have argumentation that instead of addressing the substance, tilts into ad hominem claims about the people that are making the arguments in order to avoid discussing the substance. And this is, it's McCarthyist, right? That is essentially what McCarthy was trying to do. But even worse, and I do not take this the wrong way, because I don't want to suggest that anyone is of that kind of evil. But this is the essential idea that Goebbels tried to enforce of targeting enemies and labeling them with inhuman names, octopus, rat, and making it so that instead of people to engage with in civil discussion, they're people who have to be attacked. Now, again, I'm not saying, it's really important that I stress this, I do not want to say that any one of the people that are writing in Haaretz tentacles about a Kohelet policy forum are Goebbels, as evil as Goebbels, are Nazi. What I am saying is that there is a way of discussing things that is ad hominem, and that it's dangerous. It's frankly dangerous. It encourages people to use their fists when they should be using their lips.
So returning to the substance then, we've had a few questions on the question of reasonableness, and in particular reference also to the UK irrationality criterion in the context of judicial review here. Yuval, perhaps could you say a few words, I know that you're based in the UK at the moment, on perhaps a comparison between the UK standard of reasonableness and that has been adopted by the court in Israel?
Yeah, maybe if I can just steal 1 second and maybe put, it's important for me to address one important point that Avi raised about reversing the clock back to the good old 90s or before Barak came into power. And I should say that I'm a big fan of Aaron Barak. I think he's one of the most important judges in the 20th century, but that perhaps is beside the point. I think it is important. I think the question really before us is if, even if Avi is right and the court has mismanaged and took away power, accumulated power that it shouldn't have, and I dispute that. What are the checks and balances that Israel has? Under the proposed system, what is going to be the institutional pushback on any idea that the coalition wants to pursue? And the truth is that in Israel, we only have one institution that does that, and that is the Supreme Court. This is the only institution that can apply some review over governmental policy. I mean, the UK example that was mentioned, and I will segue into the reasonableness test, but the UK example is very different because in the UK, you do have two houses of parliament. The UK, you do have very active human rights review by courts under the Human Rights Act, and there is a tradition of actually following declarations of incompatibility. There is also a joint committee in Parliament that reviews compatibilities of statutes with human rights law. There is the European Court of Human Rights. And I think there is also, and this is something that Israelis are less comfortable in discussing, but there is also a cultural acceptance of things that are not done. And in Israel, unfortunately, this is not the situation that we are at. So going back in time and removing the power of the Supreme Court means that Israelis are losing all of the rights that they have accumulated in the last 30 years and before. So now, regarding
Yuval, just before we move on to reasonableness, can I just touch on that briefly? Because there are other questions about the similarities and differences between the Israeli system and that here in the UK. And I appreciate you talk about the checks and balances in the UK, but every system is different. One may say unique. What do you say about the checks and balances of the unusual system of coalition governments, proportional representation that exists in Israel, and the limits on governmental power that are necessarily implied by having to have multi-factional agreement to pass any?
Yeah, I mean, this is, sometimes it does, I mean, having different parties in the coalition, when the coalition is diverse, is, of course, a significant check on power. And this is why we haven't seen this agenda push forward for many years. But when the coalition parties are aligned, they are more or less homogeneous, then there is nothing actually that could save us institutionally. It's really a question of gambling on the precise configuration of the coalition parties. By the way, the situation in Israel has its advantages, having diverse coalitions, but also has significant disadvantages, because as a condition for joining the government, a small coalition party could actually demand that it would not join the coalition unless the entire coalition backs a very controversial agenda, such as granting the ultra-Orthodox sweeping exemption from military service. So in Israel, it's not only tyranny of the majority that is concerning, but also tyranny of the minority, that you have small groups that are disproportionately powered. So this is a very, very thin safeguard that we can latch onto. On reasonableness, just let me say, Israel did develop its reasonableness test on the basis of the UK experience. The UK does have in the 1940s a case called Wensbury, where it did emphasize that the government couldn't actually adopt policy that is completely irrational. This pretty much follows the American approach of arbitrariness and capriciousness. The Israeli system is largely in line with those approaches, may have gone a bit further during the Barak years, and that I will agree with Avi, especially in the area of political appointments, where the court has been confronted by a culture where corrupt politicians have been still appointed to positions of government, and the court has applied the reasonableness doctrine to remove these politicians from office. This has been controversial, and by the way, the president's platform recommends to remove that specific power going forward. I'm not convinced myself that it is very bad for the court to have this, but I also don't think that this is really the most important issue that is at stake at this point in time.
Avi, could I ask you first perhaps to address reasonableness, and then I want to come on to minority rights?
Okay, so let me start with reasonableness. It's true that Israel shares language, the term reasonableness, with the UK and to a lesser degree with the United States, but these are not the same doctrines at all. There is absolutely no relationship whatsoever between, let's say, what's called in the United States striking down administrative action for being arbitrary and capricious, and in Israel for striking it down for being unreasonable. And it's not just about political appointments, although political appointments are a terrific example of the way these doctrines have nothing to do with one another. Right? So in Israel, so-and-so gets proposed as an appointee for chief of staff, and it's claimed that he had some housing code violations in the past. Nothing, by the way, that's ever been proved. It hasn't even been raised in a court case, it's before it even gets to the court, he's forced to resign because it's very clear that the court is likely to rule that it's unreasonable to have appointed him. No such thing could ever happen in the United States. The United States no U.S. court would get anywhere near something like that. You want to go beyond that? Talk about the recent celebrated cases. The Supreme Court rules that it's unreasonable for a minister not to resign in light of the fact that he's been charged with or has been convicted of or some offense, notwithstanding the law says otherwise. Again, this is not something that could ever possibly happen in the United States. Call this reasonableness or not. You have these actions in Israel that get before the court that just could not possibly ever be addressed in U.S. courts. They would be thrown out as non-justiciable to begin with. But if they ever got there, it would be obvious that the only thing that the court can use reasonableness for is to uncover whether the true nature of the acts has been presented, right? And if someone imposes a tax on all, I'll give you a famous 19th century US case. Somebody imposes a tax, San Francisco imposes a tax on all dry cleaners. It just turns out that the only people paying this tax are the 500 or so dry cleaners that are owned by Chinese. None of the 500 or so dry cleaners that are owned by non-Chinese, right? And what the court said is that you look at this enforcement pattern, just not credible that this is about tax law. This is about something else. Now, it's possible to get something that's manifestly unreasonable. None of that has anything to do with unreasonableness doctrine as practiced by Israel. What Israel does, what the Israeli Supreme Court does, is strikes down actions with which it disagrees on policy grounds. And that places the court in the position of carrying out politics and being seen as a political actor. It is devastating to trust in the courts. It is not something the courts are equipped to handle, and it is something that there are no legal grounds in which they can possibly reach decisions. Now, I want to get to the thing that the first point that Yuval mentioned. Now, this is I think one of the arguments that the Israel Democracy Institute came up with. It said, if you look around the world, what you'll see is there are all sorts of manners of limiting powers of democratically elected governments throughout the world, and they have this sort of grab bag of different elements. Ceremonial other bodies of parliaments, the ability of international courts to issue declaratory judgments, all sorts of other things. You take all those all together, combine them with places like the United States with the actual balance of powers between the federal governments and state governments. They say you can see everyone's limited except for Israel. But then, as you pointed out, Israel, it turns out, has and always has had quite limited elected governments. Every parliament in Israel, not only is it no parliament ever lasted a term, no, in most of the cases, the government doesn't even last a term, right? There are 1.5 governments for every parliament. And that's because they're constantly sitting on a sea of intrigue. And they're sitting on a sea of intrigue because, as you mentioned, Israel has, unlike the UK, it has a system of proportional representation, which means that no party has ever won a majority in the parliament. And it looks like we're nowhere close to ever getting any party with a majority. Now, under that system, you can see this with the last government. At any given point, if there's an agenda that is controversial, there are parties on the edge, individuals on the edge, who are willing to spill over and, if necessary, topple the government. And in fact, that's what lies behind the entire political debate now. I've argued to you that I think that most of the arguments that are being made against the reform are insincere. I think that the primary goal of the opposition is to create a sense of chaos that leads people to lose confidence that the government is able to act at all in order to bring about no confidence and new elections. Now, that's not a crazy strategy. It's worked before. It worked, I think, in the last government. It worked against Netanyahu in his first term back in the 1990s. It's a viable strategy because governments are so weak. There is, and I think that one of the best proofs of this in the pudding is the proposal that Gantz made at the IDI when Gantz proposed essentially eliminating the ability of the parliament, of the Knesset, to topple the government by no confidence votes, right? But I think it was essentially pointing to that. The governments are unstable in Israel. They always have been. They were unstable before the Barak Revolution. And again, the idea that somehow or another now we need to have unlimited, and it is unlimited power of the Supreme Court over the executive and legislative branches, lest otherwise we turn into an illiberal, undemocratic state, flies in the face of our lived experience. There was an Israel before the Barak Revolution, and it was a liberal and democratic state.
So, Avi, if the reforms go through, what are the protections for minority rights?
there is no better protection for minority rights than proportional representation. That's what John Stuart Mill wrote 200 years ago. I don't know if any of you remember this. There was a proposal by Bill Clinton when he was president of the United States to appoint as the Assistant Attorney General for Civil Rights a Harvard professor by the name of Lonnie Guinier. Lonnie Guinier was asked what her program was for protecting minority rights, and she had a very controversial one. It was proportional representation, and that was considered so terribly radical that she was forced to withdraw her candidacy. I think that proportional representation is the optimal way of protecting minority rights, precisely because it is it's not given to a particular institution that you're supposed to believe without any checks on it will necessarily advance the rights of all minorities, because they don't. The Israeli Supreme Court does play favorites. And so the rights of the ultra-Orthodox have not been well protected in the courts. And I'm not simply talking about striking down legislation to get rid of their draft exemption. I'm talking about repeated rulings against their rights to get welfare benefits, where the Supreme Court is, on the other hand, argued that there's a constitutional right to receive welfare payments. You look at the way the proportional representation system has worked out in Parliament in Israel. It has worked out that there's excessive protection for minority rights. All you have to do is be willing to play the game. And if you are willing to sacrifice on what the rest of the country thinks are the primary issues, and go to secondary issues, draft exemptions, welfare benefits, tax exemptions, illegal construction, as was done in the previous government with the Ram party. You can have your agenda completely filled every time, and this is because, again, Israeli governments are inherently unstable. They never last a term.
Yuval, are there minorities that aren't protected by the Supreme Court? And what would you say are the constraints on the Supreme Court at the moment, pre-reforms?
Well, I must reject the whole idea that proportional representation is an institutional safeguard for minority rights. I mean, this is exactly why we need a constitution, and most countries have a constitution. And this is why we need a Supreme Court to enforce the Constitution. And this is what happens in the vast majority of countries. And even those who do not have a constitution still find ways to uphold minority rights. There are no safeguards within the Israeli system for minorities. 20% of the Israeli population is Arab. And only once in the history of the state, they had representation in government, which was for the last government. For the vast majority of time, they did not have. And there are, of course, other minorities. I mean, look at how many women are in the current government, and how are women faring off in this current coalition. Look about LGBT rights and this coalition. So asking Israelis to put their trust in proportional representation to protect their interests, I mean, this is, I think you see on the streets how Israelis feel about the idea that it would be Ben Gvir and Smotrich and the other and the rest of the characters that are currently running the show. Again, some of them with criminal indictments and criminal convictions. You can see why many Israelis are feeling extremely uneasy about the situation. Not to mention, of course, that there are also asylum seekers, which is an issue also in this country, which is discussed. Who proportional representation doesn't do anything. Not to mention there are 2.5 million Palestinians in the West Bank, for which proportional representation doesn't get any way. So all of these constituencies, the only avenue of relief that they have which is institutional, is the Supreme Court. Has the Supreme Court done a great job in protecting them? No, it has not. It did protect here and there some rights of some groups. It has found ways, but fundamentally, there are serious problems of human rights problems in Israel. There are serious problems of discrimination against minorities, be they women, be they LGBT, be they Arab, be they Palestinians, be they asylum seekers. And the court has provided some modest relief in some cases. And the whole idea that the court is this liberal bastion of unlimited power. This, I mean, to people who, I mean, my colleagues who work in human rights and bring cases to the court, this is a cruel joke. I mean, some of them are no more willing to even go to the Supreme Court because the Supreme Court does not provide them almost always a relief. I should also say that, and maybe this is the closing remark, I mean, Avi provided a picture of the Barak Supreme Court, which I think is really inaccurate, even at the time, but now, 20 years later, when the Supreme Court's own composition has radically changed and has become much more conservative, to try to portray the Supreme Court where you have settlers on the court, where you have religious Jews overrepresented on the court, this is, again, a very distorted picture of reality. Thank you.
Well, you're right that we are overrunning because there have so many questions that we haven't been able to get to. Just to clarify for some of our audience members, because the question's been posed, of course, when you have been referring, the two of you, to Barak, that is Aaron Barak, the former president of the Israeli Supreme Court, who I believe embraced the term judicial revolution as to describe
constitutional revolution.
Constitutional revolution, forgive me, to describe the reforms or the changes that he brought in. Yuval, you've mentioned the demonstrations on the streets, and perhaps that might be an issue to end with. I'm wondering of your opinion of the surge of these demonstrations that we've witnessed, and whether they're addressing the reforms per se, or whether they are in fact aimed at a revolution to bring down a democratically elected government, a government that many have argued has a mandate with respect to these reforms. Of course, the proposals are not new. They've been under discussion for some 10 years and played some role in the discussions during the last election. And there is reference here to another Barak, Ehud Barak's recent remarks to Chatham House in London, where, amongst other things, he was advocating regime change, citing research on civil disobedience to cause a government to fall or capitulate, and supporting the campaign on this basis. Could I ask very briefly what you say to those that are viewing these protests as oppositional to the government and a rejection of the last election result, as opposed to so much the technicalities associated with these reforms, which have been under discussion, which have in fact also been endorsed by opposition members over the years previously, including Lapid, who I think gave a talk talking about the unconstrained power of the Supreme Court at Kohelet. To what extent are these protests political and aimed at toppling the government, as perhaps Ehud Barak has indicated?
No, Lapid didn't support these reforms. This is not true. I mean, he did support an override, but a very high override. Nothing that looks like what is being proposed. No, I don't think that what we see on the street is political in the party sense. It's not people who want to bring down the government. It's not that people are necessarily. I suppose that many people on the street did not vote for the government and would be sad to see it gone. But this is something very different. And you also have a lot of voters from the government who are actually on the streets. And you actually also, as I said, in terms of polling, you have 2-to-1 polling, including many supporters of the government who are opposed to these reforms. These reforms were not part of the election campaign. The Likud never brought it forward. It was one of the smaller ultra-religious Zionist parties that put it forward. Netanyahu, in his inauguration speech, never even mentioned the reform as part of its agenda. And suddenly, from almost day 2 of the government, this is the only thing that the government has been doing obsessively. I think what you are seeing is a genuine protest against the reform, but also against something which is more fundamental. And here I think there is an issue. And the thing that is more fundamental is really whether the Israeli social contract is viable. And I think people are feeling that a social contract in which you have a large group of the population that goes to the military, pays taxes, performs its civic duties, but then the government takes away their rights and is actually channeling resources towards other groups in the population that are less involved in sustaining the country. They are not serving in the military, they're not working, etc. I think this is a formula that is no longer acceptable in the eyes of a large chunk of the Israeli population, and the reforms are really creating the infrastructure that will perpetuate this state of events. So this is, I think, what is fundamentally at stake. It's not whether Likud or this party or that party would win more votes.
Avi, what's your take on the protests, perhaps finally, and then we'll conclude.
There is something to what Yuval is saying. I don't think that he's quite appreciating what he's saying, and that is, I think that what we're seeing with the protests is not particularly about the ins and outs of the reforms, nor are they particularly about political parties. They're about a sense of a particular group of people that haven't thought of themselves as an interest group. They've thought of themselves as Israel, and they're on the streets because they're getting the sense that they don't have a majority in this government, and they fear, incorrectly, by the way, in my opinion, but they fear they may not have a majority in the next or in the government after that, because the way they read the demographics, they're not going to be the majority in the future. And they're questioning why it is that in a democracy the political priorities get to be that of the majority. Right? That's why is it, as Yuval said, why should budgetary allocations be according to the political desires of the winners and not the political desires of the losers? And the judicial reform is related to it, because one of the ways in which over the years the particular elite to which both Yuval and I are alluding has been able to avoid the consequences of losing elections is the Supreme Court and the legal bureaucracy, which have consistently blunted or pushed aside political directives that they didn't appreciate, while pushing forward other ones that they thought were more in line with their ideological agenda. And it's democracy is a very uncomfortable system. It's a system which you have to be ready to lose sometimes. You have to be ready to understand that the ideologies that you don't agree with have sometimes win over a majority of the public, and they have their day. Now, I don't agree that it's in describing this as basic rights. I look at the Supreme Court, and there I'll have to agree somewhat with Yuval as well. It isn't particularly liberal, right? Now, Yuval may think that it's been insufficiently protective of the rights of the groups that he favors. I will tell you that it definitely is insufficiently protective of the groups that are in support of judicial reforms, because they've experienced it. They've experienced the way the court is not particularly protective of their rights of free speech and their political rights and their other rights. The rights and the rights of the criminally accused are, I think, insufficiently protected in Israel, and that's the doing of the Supreme Court. And it's particularly felt by those who are politically targeted by law enforcement. Yuval would point to some people, and I would point to other people. That doesn't mean, well, either of us is wrong. But ultimately, let me just say something. I'd like to say something hopeful before we leave, which is, there's a large majority that, whatever you think about the particulars of the reform, there's a large majority that actually favors reform by consensus, that is, reform by compromise. And what the nature of that compromise is, well, we may not agree, but I actually think that there is room, if we're willing to turn down the heat a little bit and to stop classifying people as evil, enemy, etc. And to stop looking at this. This is not about the judicial reforms are about the extent of the powers of a particular institution of government. They are not about whether Israel is going to continue being a democracy. I believe it will. It's not about whether it's going to continue being a liberal state, because it most certainly will. right? Majority of Israel will remain liberal no matter what. That's not the question. The question is, can we, as a society, gather together with reasonable voices and reasonable thoughts, come together to reach some sort of a compromise to return this institution to a reasonable set of powers? And I think we can. I don't see any reason to worry that everything is lost. It's not all lost. And I invite Yuval to join me in that.
Gentlemen, I'm apologies for overrunning, and I know you're both very busy individuals. We really require a few further hours together to start to do this topic justice. I'm extremely grateful to both of you for your insights and your time, and to our audience for sticking with us despite the lateness of the hour. We'll, I'm sure, be returning to this issue, and I echo your optimistic thoughts there, Avi. It seems that there is or has been some area of agreement between the two of you, as well as, of course, the opposing insights, which we're all very tremendously grateful to you both for providing. Thank you so much.
Thank you.